Rosma was injured when a piece of glass slashed her arms. Whether Rosma can take a legal action against of Mega Greenhouse for negligence. Negligence means lack of proper care and attention. Legally, negligence means the breach of a legal duty of care, which results in damage to the claimant undesired by the defendant. There is a duty of care owed by the defendant to the plaintiff. There is a breach of duty of care by the defendant. The breach caused the claimant reasonably foreseeable damage. Applying the above principle to our present case, Mega Greenhouse have a duty of care to the Rosma and Kai. Because Kai and Rosma went to Mega Greenhouse and suddenly lorry, loaded with fertilizer driven by Salong, which is employee of Mega Greenhouse, hit the main pillar at the entrance of Mega Greenhouse, causing the glass roof to cave in. It is very important to note that the standard of care is measured through the standard of a reasonable man test. In the case of Blue vs. Birmingham Waterworks Company, the judge said negligence is the omission to do something which a reasonable man would do or doing something which a reasonable man would not do. For the third element, damage suffered by Rosma and Kai because of Rosma's fear that the broken glass pieces falling down from the ceiling would injure her husband. Rosma instinctively pushed her husband out of danger. From doing that, she was injured when a piece of glass slashed her arms. Here, Rosma suffered because of breach of duty by Mega Greenhouse. To prove this, the test used is the but-for test. The answer is no, so she must proceed with the remoteness of damage. In this case, Rosma must proceed this case to prove that the injury is foreseeable. Therefore, since all elements are fulfilled, Rosma and Kai have right to sue Mega House Holiday due to negligence. Whether Mega Greenhouse can use their right to defense theirself?
According to the general rule, the burden of proof lies on the defendant to negate liability for a particular tort. The defendant can prove that a duty was not owed, or it was breached, or that the damage or injury was too remote from the defendant's act or omission. Defenses which are usually raised in negligence suits are I. Contributory negligence 2, Volonté non fit injuria 3, Exclusion clause. Thus, the claimant can still make the claim against the defendant, but the damages he receives will be reduced by the amount the claimant was to blame. Referring to Nettleship vs. Weston case, whereas a driving instructor was injured by his pupil, learner driver, when the pupil negligently crashed the lamppost. The issue before the court was whether or not the learner driver could be held for the negligence he caused. The court held that by being on the road, the learner driver is expected to behave a reasonable driver. His damage reduced 50% to reflect the degree to which he was also at fault. By applying above case to our present case, assuming Mega Greenhouse can defenses under contributory negligence, which means that Rosma and Kai's claimant contributed or were partly to be blamed for the damages suffered as a result of some act or omission on their part. In this case, whether Mega Greenhouse can defense is that Rosma pushed her husband and contribute to injury she get. Referring to Section 12(1) of the Civil Law Act 1956 provides that where any person suffers damage as a result partly of his own fault and partly of the fault of any person, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damage is recoverable in respect thereof shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility of the damage. Therefore, Mega Greenhouse cannot raise any defense in this case because Rosma and Kai got damage as the result of this incident. I think the defendant's excuse to defend is unreasonable, as Rosma and Kai is not with the lorry driver to contribute and cause the incident.